Grace after grief, our story for His glory.
All right. It has been some time since you were here.
Yeah.
You had a great holiday.
We did. We had a good holiday. We've been back since Sunday, so I did yoga at Disney Hollywood Studios. That was super fun.
Very cool.
First bucket list thing for me to do there for like the Disney Run thing. And then we had some Disney days, and now we're back here spending some time with some families.
All right.
Pretty
Very
good vacation so far. How have you been since the holiday?
I have been wonderful. So really, I mean, we are in the month of March right now, just so everybody else knows what's going on. But when we recorded last time, it was December.
Yes.
So we've had a few things. I had a wedding. My son got married.
Congratulations.
Christmas.
Again.
All those wonderful things happened, and it has just been really busy. And I can't believe we're already in March.
I know.
It's just crazy. So we want to introduce you to Pam Carlson. Pam is in the office in the studio with us today, and she is a local attorney specializing in estates.
Right. So I'm actually board certified in real estate, which is the only thing I can actually say that I specialize in under the Florida bar rules. But my practice is heavily entrenched in estate planning, elder law, and things associated with that, like probates and trusts and that sort of thing. So I've been practicing, I haven't got it right yet, but I've been practicing for roughly 32 years, which is hard for me to believe.
Right. Yeah.
Yeah. So thank you for having me.
Well, you're absolutely welcome. I said you were the first person I thought of. I've known Pam for many years, both of us being in Lake Placid for a long time. I think you're a lifetimer, yes?
I grew up here. Yes, I did.
Yeah, I'm a transplant. I came later, but yeah, it seems like a lifetime. So, but we just wanted to make sure that our listeners have a better understanding of how to prepare. I think information that is able to be used now to put into practice now, so that when something comes, and death comes for all of us, we've talked about that, whether it be for ourselves or if we're helping a loved one prepare. I wanted Pam here to kind of help and guide us. And obviously, she is an attorney, but we suggest that you seek your own attorney, and find out the information that's pertinent for your state if you're listening someplace else. So we're going to hit it today. We've got quite a few questions for you, and you can bounce around on those questions. You can do whatever you want, but I sent her a few questions. I think she's probably a little OCD like I am, and we're going to stick to that.
Sounds like a good plan. And yes, I am only passed the bar in the state of Florida. It's the only bar I ever took. And so everything that I talk about today and speak about with respect to the law is pertaining to Florida law.
Perfect. So, all right. So let's just start out with when someone loses a loved one unexpectedly, what legal chaos do families most often face?
Sure. Well, just first of all, they're going through an immense amount of grief, and that clouds everything. But the first thing that families are dealing with is making the funeral arrangements if they haven't already been made, dealing with the expense of that, which can be pretty hefty depending on the type of arrangements that the family chooses. Dealing with bills that are going to keep coming in. Just because somebody passes away doesn't make the bills stop. And in present day with the digital technology and everything, not knowing usernames and passwords that the loved one used. And, we all have those lists that we keep of passwords and usernames. And the thing is, when we go in to try to use that password, and it like automatically makes you update it, or you can't remember it, and so you have to do the forget your password and get a new password. If you don't update that list, then the list doesn't do us any good,
Correct.
So the chaos of trying to figure out where the assets are, how do I get to them, what debts are owed, are there any benefits that I need to seek out for the loved one? Like, do they have a pension plan? Are there any life insurance policies that I need to file a claim on? how many death certificates do I need
Mm.
to make
That was
all
a big
those
one.
Yeah,
claims?
definitely.
You know, for every life insurance policy, you need a death certificate that has the cause of death,
The long form.
the long form.
Mhm.
But for your attorney, and for like real estate transactions and things that might come about, you need the short form, not the long form. The long form has the cause of death on it, and that you know, we're recording it and things like that, we for privacy reasons we have to have the short form that doesn't, you know, have that cause of death. There's notifying Social Security if the person was receiving Social Security, notifying them to get that stopped. If you're a surviving spouse, there's a one-time benefit that you can get. It's like $255 that you can, you know, apply for. If you are making less than your spouse on Social Security, you can apply for that spouse's benefit, if depending on the length of your marriage and things like that. But figuring all that out.
While you're grieving.
While you're grieving.
While you're grieving,
Right.
while you're dealing putting it together. But if you have it at least and it becomes something, then you can start working on those things where if something happened to you, then at least somebody can pick up and say, okay, at least I know they wanted XYZ, or I can find, I didn't know they had a life insurance policy. Now I know they have one, or whatever it is. So yeah, that's the hardest part. Is I don't think people realize how much trauma you are dealing with at that time. And then of course it's, for us it was unexpected. So then you have that on top of it. So that's the hard part, I think. That's really, I mean, like I said, we could sit on question 1 all day, but we do have lots of other questions. So how does having an estate plan in place actually reduce grief stress for the surviving family member?
So, having the estate plan can significantly reduce stress because many times having stable plans in place for a long period of time and not just last minute can help reduce litigation that may come about as a result of somebody's passing. When last minute changes are made, that can cause an instability in the plan and can create a basis for challenging it, which just what, somebody needs when they're going through this trauma you just described is to insert, litigation into the mix. But, having the plan in place, letting family members know what your wishes are, not the ability to communicate even during your lifetime with your family members about what your plans are. It's the surprise sneak attack disinheritance can cause immense family
The tension
drama,
and the-
Right, absolutely.
and
yeah.
so just making sure that if you're going to go ahead and disinherit someone, tell them, have the guts during your lifetime to let them know that, look, for this reason, I'm not making a plan for you. I'm not including you in my estate plan. And then you deal with the fallout rather than your family members after
Can you
you're gone.
imagine having to go through that at the same time? Like you sit at the table and cousin Eddie thinks they're going to get something, and then you're all at this table talking about it, and he's like, "What about me?" And you're like, "You're not in here. Sorry, no mention of you." But I thought I was the favorite. And well,
I think that's a great point. I mean, I think that us as humans don't want to deal with hurting people's feelings, I guess, but I mean, that's not fair for you to be like, yeah, you get nothing, but I'll be gone, so it doesn't matter. Like, that's not fair. So that's a great point, Pam. Thanks for bringing that up.
While she was talking, I know that it's so hard to talk about death for me and for us. I think it's just something that we started, and maybe a lot of widows, maybe people who have gone through this, it becomes easier. But for me, I it's not a taboo subject anymore. I've had the conversations. I want to continue having the conversations. I'm not saying, like, but we do. We talk about our future plans. We talk about vacations. We talk about all these things openly, but then all of a sudden we're like, oh, I talk about, planning my funeral, and I don't really. It's the best thing that you can do for the people that you're leaving behind.
Right.
Mm-hmm.
Those prearrangements and letting, taking care of all of that for the family members. So all they have to do is just contact the funeral home and let them know everything, that you're gone. Everything will go so much more smooth. And, they're not trying to deal with what did they want or, that kind of thing.
That's
so it's
huge.
absolutely
That's huge.
huge to have that in place. And it significantly reduces.
Because it's going to be stressful enough. Let's just, it is stressful enough. You can't, no matter what, you can't do anything about it. So what are the essential documents every adult should have, even if they don't think they have a lot of stuff that they need to divvy up?
Yeah. So a last will and testament, that's the instrument that says who gets what, right, when you're gone. A durable power of attorney, a healthcare surrogate, and a living will. So the durable power of attorney is the financial power. It lets somebody during your life, because the power of attorney dies when you die. So during your life, the power of attorney can handle financial things for you. They can go to the bank. They can make insurance claims. They can file for benefits you might be entitled to. They can handle tax returns. They can pay your bills. They can just anything that you do financially speaking, your power of attorney, can do for you. The healthcare surrogate is another kind of power of attorney, but it's for medical decision making.
Okay.
So that's like where you're residing, what doctors you're seeing, what medicines you're taking, what treatments you're having, who gets to visit you. These kinds of things, medical decisions. And then the living will is sometimes we call that an advanced directive because it's you in advance saying when you no longer want life prolonging procedures and artificially administered feeding and fluid. So you can choose, in Florida anyway, you can choose that you don't want those things if you're in a persistent vegetative state. So that's like a permanent coma, brain dead kind of stage. So if you're in that stage, you can say, okay, if I've reached that level of medical condition, then I don't want to be kept alive. Take me off machines. Don't do CPR on me. Don't feed me intravenously or through a G tube or anything like that. Another stage is end stage condition. So you can choose, okay, well, I don't really have to be in a vegetative state, but if I am at the end of life, there's no reasonable medical probability that I'm going to get better. Stage 4 inoperable brain cancer or something along those lines, where there's just nothing. The doctors are saying there's no hope, right? You can say that that's the stage that you don't want them doing CPR on you or providing you with artificially administered feeding and fluids or doing things that are going to keep you alive, like dialysis. Right. So then the other stage is terminal condition stage. And, that's just when you say, look, if I have a terminal condition, that could be any condition that without treatment, you're going to pass. So even stage 1 is a terminal condition, stage 1 cancer. So a lot of my clients don't choose that one because they're not quite there yet. But that would say if I have stage 1 cancer, I don't want you doing CPR on me if my heart stops, or I don't want you doing anything that would keep me alive artificially. So again, it gives us 3 different stages of medical.
I had no idea that you can actually
pick.
drill it down basically.
Yeah, you can pick, and then of course. There's also another document that is not a legal document. It's actually a medical order. And a lot of people confuse a living will with a DNR. A DNR is a do not resuscitate order. It's an order because it's a medical document. A medical doctor has to sign it. And that just says do not resuscitate. And you have to it's the only thing an EMT or EMS is supposed to follow. They don't have to follow a living will. But if you
Oh,
have a
okay.
DNR, they're supposed to follow your wishes. It has to be displayed on your refrigerator. You need to, if you're not in your home, you need to have some sort of medical ID that lets them know you're a DNR patient.
Crazy. There's just, see, I'm so glad you're here today. You give us so much more information because I had no idea that, number one, like you said, you can just make so many choices. And those choices should be made now, because if not, think about what you're leaving your family with. That's the hard part. And that's what we're trying to negate now, is that, be prepared, be prepared. So, if someone doesn't have a will in place and they pass away, what happens next?
Sure. So, well, it kind of depends on how their assets are structured. So if it's a married couple and everything that they own is owned as husband and wife or as joint tenants with rights of survivorship, then everything is going to automatically pass to the surviving spouse, right? There's not a probate. There's not a need for any administration of the will, as long as that's true. However, if you die in Florida and you don't have a will and you have assets that are in your name alone that you do not have a beneficiary on, okay, then we have something called the Florida intestacy statute. And that just means that the state of Florida in the law has written a will for you. And a lot of people say, I don't want everything to go to the state. It doesn't go to the state. The state has written a will, and it says that if you have a surviving spouse, the surviving spouse gets 100% of your assets unless you have children who are not also the children of the surviving spouse. If you have children who are not also the children of the surviving spouse, then that the surviving spouse gets 50% and the descendants of the decedent get the other 50%. So that's usually not what the person would want. The person would usually want their spouse to get everything. And so if you don't have a will, that's not what's going to happen if you have children from another relationship. If there's no spouse, then everything goes to the children. And if a child has died, that child's children get the grandchildren, get that child's share. If there are no children and no grandchildren, so no descendants, then to the parents of the person who died. So if the parents are also deceased, then it's going to go to the decedent's siblings, brothers and sisters, if they have any. If they have no brothers and sisters either, then it's just going to go to the next of kin. So think cousins, for example.
So they just basically have to come in and say, this is how I was related?
Yeah. So in that kind of situation, I had an estate last year, maybe it was last year, that I represented a beneficiary that was 1/32nd interest in the estate. And there were beneficiaries in that estate that were 1,617 interest. So this guy passed. He had no parents, no siblings, no nothing. So it went to all the next of kin. And the attorney that handled it had to hire an airship determination company that goes and does genealogical searches and finds all the next of kin and then reach out to.
So there you go. That I'm going to have to insert this. Like, okay, your uncle died. Here's your $1.25. Like, that's crazy. Oh my gosh. So the point is, be prepared.
Right.
Have a will. Have something. I mean, the bare minimum would be at least a will.
Well, and I think it's malpractice to just do a will and not do the supporting documents that I went over, because they are almost as important as the will is. If you don't have a power of attorney or a healthcare surrogate and you're incapacitated, that means a guardianship has to be done, which is extremely expensive, extremely complicated, very, very lawyer, doctor, psychologist, psychiatrist, intense. And there's all kinds of training that has to be done for the person serving as the guardian. There's all kinds of fees associated with it. We want to avoid guardianships.
Right.
And so I think it's almost tantamount to malpractice to not do. And so I just don't. If somebody wants just a will, then they're going to go someplace else, because that's how strongly I feel about the support.
Very good. Very good. Good to know. If someone is in a second marriage or a blended family, and I think you kind of covered a little bit of this, are there extra planning steps that are critical?
Right, yes, because obviously if you don't have a will, we're going to have that 50-50 split. But then also, um we when there's a second marriage, we really, as planners, we like to see a prenuptial agreement in place, because that prenup is going to give us a roadmap for what's supposed to happen if there is a divorce or if somebody passes away. And it's going to protect the family of the person who passes away. But if that's not in place, then a lot of times what we'll do is we will suggest that they do a trust that would become irrevocable as to half of the value of the assets in the trust at the death of the first spouse, so that at least half of the monies are there to and protected for the children of the deceased. Now, the issue is who's supervising this? Do we put one of the kids of the deceased as the gatekeeper or the purse string holder so that the surviving spouse can't get to it freely? How is that going to go? And so a lot of times, when I'm talking to couples, they just I feel like they just decide they're going to roll the dice, and whoever survives, whoever is going to get the control of what happens. And so they'll just do a simple will that says everything to each other, and then everything to all 6 kids, the Brady Bunch, right?
Right.
And then, in spite of my admonishments that this isn't a great idea, and then the one dies, and then inevitably the surviving spouse comes in when time has passed and the relationship has declined because there's no more common bond. And they come in and they change the will, and they write out the 3 kids that were the surviving, the deceased spouse's kids.
So if they had that in place, then at the time of death, they would go ahead and make
they don't go ahead and give them the money at that time, because the surviving spouse might need it for what we call HESM, which is health, education, support, and maintenance. But we try to put a gatekeeper on it, maybe again one of the kids of the deceased spouse. But I'm telling, the couples don't want to be the one who has to go through the gatekeeper to get to the money that they feel is theirs.
Right.
And so it creates, even though it's designed to protect the kids of the first spouse to die, it can in and of itself cause problems. And there's all kinds of not necessarily recommended ways to get around that planning, but there are strategies that are used by surviving spouses that have that plan to decant the trust, to take things out of the trust. Go ahead and sell the house. Now what do we do? Now it's not part of, there's things that happen, and even in the best of planning, that can thwart the plan, right? And so it's very difficult. And to be honest with you, most of the time when people sit down, they say they want their spouse to have total control, and they trust that their spouse is going to do the right thing. And sadly, that's not necessarily common for that to happen.
Correct. Things change.
Yeah.
Things change. So I think we'll skip around a little bit if I can get you to do that. How about we go on to, while we're still talking about it, we go on to number 8. Can you explain the difference between a will and a trust in just simple terms?
Yeah, sure.
So that we understand.
Right. So a will is where you say who gets what when you die, and you name an executor to be in charge of it, but that executor has to be supervised by the court. There is a probate that is opened, and a judge is overseeing the entire process. They're watching that executor pay the bills. They're watching that executor sell and divide the proceeds. They're watching that executor pay the taxes. So it's it's just an instrument that directs the administration of your estate through a probate. A trust is an instrument where you name a successor trustee who is going to stand in your shoes and do what the trust says that you've instructed them to do. And there's not, if it's moving and operating correctly, there's not a court involved. It's you're trusting that they're going to do what you've asked them to do. And they have, the authority to take the steps, whatever it is that you've instructed them to do, sell, divide, hold. And so a probate takes roughly a year. A trust could take less than that, or if you've instructed the trustee to hold the monies until the person turns 35 or 45 or whatever, the trust could go on, you know, depending on how old the beneficiary is.
So for me, and just in explaining it, so when you're alive, you have a power of attorney. And basically, when you pass, if you have this trust in place, it kind of becomes your power of attorney past death because you've assigned somebody to act on your behalf, even though you're not here.
Correct.
Is that okay? Okay. I just want to make sure I
But
kind of understood
and
that.
just as a point of clarification there, interestingly, the power of attorney has no authority over trust assets. So if you have a power of attorney during your lifetime and you have a trust that's funded with your assets, the power of attorney can't do anything with those assets unless they're
Oh.
also the successor trustee.
That was
Oh.
my next question. Could it be the same person?
It can.
Okay.
Yeah.
Okay. Very cool. Okay. So I think we touched on number 9 a little bit already, what a power of attorney is and why does it matter. So we've talked about that, but is there a difference now? We talked also, I think we've touched on the living will and the difference between that and a healthcare surrogate.
Right.
So I think did we have any questions on that one? Are you, I
No.
mean, if you understand, I understand it. We hope you understand it too. If not, reach out to us and we'll get you in touch with Pam. What happens? I think this is a big one because for me, when Larry passed, it was a shock for me. Obviously, Larry went through a lot of treatment at a hospital and had chemo and radiation for many weeks, and he had insurance, and insurance covered part of it, obviously, while he was alive. And then when he passed, I got this ginormous bill from them, and I was like, what do I do with it? And I found out that it was in his name, and I didn't have to send them a death certificate, and I was like, I mean, I thought, okay, I'm just going to pay $25 a month for the rest of my life, and then it's going to go to my kids, and they're going to have to pay $25 a month for the rest of their life. But I didn't, and I didn't understand that. I mean, I knew that credit cards, if you have credit cards and you're in each other's names, and you don't have joint credit cards, then if something happens and that person dies, that credit could actually get washed because your name, the surviving spouse, wasn't on it. But I didn't realize the medical bills. And so what happens to a debt when someone dies?
Well, it depends, as you just kind of spelled out. If it's a solo debt, meaning it's just the debt in the decedent's name and there's no probate assets to pay for it, then it's going to get written off. So if there's no probate that gets filed, that debt goes away. If there are non-exempt probate assets, then the creditors are going to get paid before the beneficiaries get paid. So if there is a probate and there's non-exempt assets, so your homestead is exempt, your car is exempt, about $20,000 worth of tangible personal property is exempt. Everything else is not exempt. So if you have non-exempt assets, the debt's going to get paid from those non-exempt assets before the beneficiaries take their share. And then, like you said, if it's a joint debt, meaning it's a credit card you have in joint names, then you're going to be the surviving spouses or whoever the joint debtor is going to be responsible
For that. Okay. What should single women, widows, or women who are starting to prioritize legally, what should we focus on really as if we wanted to put things together right now?
So I think widows should update their estate plans. They should file for homestead and tax reassessments that they might be entitled to a widow exemption, things like that. They're going to take care of Social Security, survivor benefits, and they may need to reassess their investment strategies and allocations based on the fact that they're just single now. If you're divorced and starting over, you absolutely should remove your former spouse from all of your estate planning documents and any beneficiary designations you have. Make sure you're in compliance with your divorce decree. Sometimes they require you to maintain some insurance or something like that. So we want to make sure that happens. And then strongly consider prenuptial planning if you plan to remarry at any point in time. And then if you're just a single person, never married, that's hard because you have to figure out who's going to have your decision-making authority. You've got to plan for who your beneficiaries are going to be when because your natural beneficiaries, your children, you don't have because you've never been married and had no children. And then, consider charitable planning, that kind of thing. Families find immense peace when there's a letter explaining any undisclosed decisions that were made in the estate planning. personal items are specifically addressed, funeral wishes are known, and there were words of blessing or gratitude in that letter, letting people know what you were, why you did what you did. And families can handle unequal distributions when they're explained, when intent has been communicated during life, when no one feels secretly disfavored or stabbed in the back. Um, Again, have the guts to do it now. And while you're alive, let them know. And then, they grieve in unity, families do, when they've had all these honest conversations. They've had an opportunity to say what needs to be said, and there's closure. They have that closure. And then maybe most importantly, death loses its sting when heaven is certain.
Absolutely.
There is sadness, but there's hope. And there's a sacred calm that comes from knowing your loved one has stepped from this life into eternal joy. And that's something that you can only have when you know that they have that personal relationship with Jesus.
So long before you prepare any of your will or your documents or any of the things that we reviewed today, saying yes to him is the most important.
Yeah.
And then everything else comes after that.
Yeah.
Because it is all of this is a gift to your family that you're leaving behind. But I think the biggest one is I know for certain that I will see my loved one again, because he believed in Jesus. I believe in Jesus. And the Bible says we'll be together again one day. So I think you did an awesome job today.
Yeah,
Thank you so much.
Thank you
Thanks for
very
having
much.
me.
It went very fast, didn't
It
it?
did. Really quickly.
We are so glad that Pam Carlson was able to join us today. Thank you, Pam. Thank you for taking the time out of your schedule and coming and answering these questions. And I hope that if you are listening and you have any questions, reach out to Pam at her office, obviously. Reach out to us. We can get you in contact with her. If you are someplace else besides Lake Placid, then reach out to an attorney and start the process. But before you do anything else, say yes to him, because that's the most important thing we just said. So, you want to close us out, Louie?
Yeah, before we do that, please like, share, and subscribe to our channel. We are trying to grow our don't want to say audience, not fan base. But we appreciate you guys. We're just trying to get the word out about Jesus, about planning, about being prepared as much as we possibly can be for the inevitable. So that's it. Thanks so much.
Thank you so much for being here. We are
Grace after grief, our story for his glory.